identifying strategies for minimizing risk and dealing with disputes that inevitably arise. Our speakers today are Adam Brooks and Erin Wilson. Adam is an associate in our Dingwall office and specialises in oil and gas. Erin works in Aberdeen and specialises as a solicitor in dispute resolution. In addition to our two principal speakers, we are joined on the panel by Brian Wilson. Brian is an oil and gas partner and joined us from his prior role as General Counsel at Total. So, without further ado, over to Adam.
Thanks, Ken, and good morning, everybody. As Ken has touched upon there, today's presentation will focus on how to manage certain contract risks with a focus on the COVID-19 world that we now find ourselves in. I will be discussing the issues around the continued benefit of committing contracts to writing, and my colleague Erin will be discussing how to manage solvency risks and some issues around dispute resolution. We should say at the outset this presentation does build on a session that Erin and I gave in Inverness in January, and if you'd like any further information on that session, then please do get in touch with us after today's discussion. Very briefly on the business impact that COVID-19 has had, it is of course something that's placed businesses under extreme pressure. Many businesses have suffered a loss of revenue and businesses remain closed. There have been global disruptions to the supply chain, and some of you now be in the difficult circumstances of trying to restart work whilst complying with the social distancing requirements. We recognise that as a result of this, companies need to be very much proactive in securing their future, and this might mean that there's a need to act quickly and to take steps to cut costs. However, there are risks associated with this approach, and what we want businesses to do is to be aware of some of those before they take any steps. One of the temptations that businesses might have in order to try and save time and costs is to dispense with the need for a written contract, which can often be seen as a nice to have rather than essential. There are some circumstances under Scots law when contracts must be in writing, and these are set out in the Requirements of Writing Scotland Act 1995. But for now, it's sufficient to say that contracts that create or transfer real rights in land, such as transfers of ownership, have to be in writing. Generally, though, a contract doesn't need to be in writing, and in fact, most contracts are actually concluded either orally or by action alone. So the question then arises as to why you should actually bother to write it down in the first place. We understand that in a fast-moving and flexible approach is going to be needed by businesses right now in order to cope with these challenging times, and that engaging in time and cost-consuming contractual negotiations can be seen as unnecessary barriers to trade. This is especially the case when negotiations have to take place up front and therefore might be seen to be preventing the commencement of performance of the contract, but also because they result in costs being incurred without any guarantee of reimbursement if negotiations are unsuccessful. Overall, the matter's forever going to boil down to balancing risk versus reward. What we encourage businesses to do is to take the time to fully assess the level of risk they're exposing themselves to in order for them to make a value judgment as to whether the reward merits taking it on. In terms of what risks a written contract can help mitigate, which aren't as well mitigated by unwritten agreements, well, firstly, it gives you obviously greater clarity as to what terms apply. There could be a significant period of time elapsing between agreement and actual performance of the contract, and during that time, what was agreed can be forgotten. It also mitigates the risk of parties acting in bad faith. If you have something that is clearly drafted in writing, you can show what terms were agreed and can minimize the risk of one party claiming that other terms and conditions applied when they knew full well that they didn't. And this might be something that's a particular risk during the COVID-19 outbreak, as businesses are struggling to stay afloat and maybe seeking ways to either renegotiate or indeed extricate themselves from contracts that were made under better economic circumstances. A written contract also avoids the reliance on institutional knowledge, and that is the knowledge held in the minds of certain key individuals within a business. You have to consider in the COVID-19 world whether that person you've agreed a verbal contract with is at risk of being put on furlough, or maybe they've been made redundant during this time. Hopefully not, but there's the potential that they're going to be off sick. And what if they're not working because some form of staff rotation is put in place in order to comply with the social distancing requirements? Some staff may only be working 1 week on, 1 week off, and you might not be able to get hold of those staff members that are at home during that whole week. Another area in which having a written contract is definitely beneficial is in respect of claims of force majeure. This crisis may be causing workplace or supply chain issues for businesses, which is out of their control and which leaves them temporarily unable to perform the contract. And such businesses may be looking for ways to suspend those contractual obligations until they're once again able to perform. This is where a claim of force majeure might come in, and Brodie's has seen a marked upsurge in requests of advice from clients on this over the last couple of months. Successful claims of force majeure will serve to suspend performance of the contract without any liability to either party until the event causing the force majeure claim has subsided. It is very much a creature of contract. There's no common law doctrine under English or Scots law, and therefore, in order to ensure that it applies, there must be an express agreement to that effect. Without this common law equivalent, it will then be critical to define force majeure. Usually the definition includes a set list of events such as acts of God, changes to applicable laws, or even war, which are out with the control of a party and thus prevent performance. Now, one of these events could be the outbreak of an epidemic or pandemic, but this may be covered by acts of God or changes to applicable laws if the wording permits. It's then often accompanied by sweeper language, which tries to catch all other things which are reasonably out with the control of the parties. But in addition to the set list of events, there will be several other conditions which have to be applied to those events in order to enable a claim for force majeure to be made. These are typically that the event must have delayed or temporarily prevented performance. It must be beyond the control of the party making that claim and must be out with that party's fault or negligence. And it must also be something that by the exercise of reasonable due diligence, that party wasn't able to provide against. There will also frequently be requirements for the affected party to give notice of the event before any claim for force majeure can be made. And there's generally an obligation to mitigate losses. Despite force majeure being a creature of contract, case law has applied certain other requirements to force majeure clauses where the wording is otherwise deficient. First of these is that there's no requirement for a lack of foreseeability of the event. It must also be the sole reason for prevention or hindrance of performance, again, depending on how it's worded. The parties must they will not be able to rely on force majeure event if there's another event that is also contributing to that prevention of performance. There are different thresholds that are applied to the wording as well, and the courts have recognized this. So for example, if your force majeure clause says that performance must be prevented, this is obviously setting a higher threshold than if performance simply has to be delayed or hindered. So you need to be very careful with the wording you use then. But a common theme through all of the decisions of court is that a change in economic circumstances will not constitute force majeure. However, this is subject to the caveat that this is all dependent on the express wording of the contract. And one of the advantages of a force majeure clause is that you can very much tailor it to suit your specific needs in any given situation. In terms of the scope or protection, a force majeure clause will generally serve to suspend performance of the contract until the event has subsided, and there'll be no liability to either party in that situation. There's often also an accompanying termination right if the force majeure event lasts for usually a set number of consecutive days or a larger number of non-consecutive days, but over a greater period of time. And the contract may then go on to discuss how payment is to be resolved for work that's been performed up to the point of the force majeure event. In terms of its application to COVID-19, the ability to claim force majeure may indeed prove a vital tool for businesses as they try to manage this period. Successful claims, as I've said, allow for the temporary suspension of contractual obligations, which can then be recommenced once the inhibiting event has subsided. The obvious benefit to this is that the business is not held liable for their failure to perform, but also they have the opportunity to retain the underlying commercial value in the contract because performance can recommence at a later date. Claims may be based on changes to applicable laws, although we advise you exercise caution here because much of what the government has said in relation to COVID-19 have actually been guidelines as opposed to legal requirements. Where there's an appropriate event under which a claim can be made, it will depend very much on the wording of the contract, and this is something that Brodie's can definitely help you in reviewing. It is highly unlikely that any verbal contracts will contain agreement on matters relating to force majeure, and even if it did, you have the evidentiary issues that we've discussed already. Therefore, by having this written agreement containing the force majeure provisions, parties may be availing themselves of very significant additional protection during this time. If, however, no written contract is entered into with force majeure provisions, then parties may be forced to rely on the common law doctrine of frustration or supervening illegality, which are different in certain key areas and may put you in a far worse position. Looking at frustration, this is a common law doctrine found in both English and Scots law, and it serves to discharge a contract where the frustrating event occurs so that parties are no longer obliged to perform their contractual obligations. The best expression of the test is set forth in the case of Davis Contractors against Fairham, where the court held that frustration occurs whenever the law recognises that without default of either party, a contractual obligation has become incapable of being performed because the circumstances on which performance is called for would render it a thing radically different from that which was undertaken by the contract. And in Latin, non haec infidera veni. It was not this that I promised to do. Looking at the case law, it has given rise to certain criteria used to illustrate satisfaction of this general test. There must be an external event. It must have occurred after the contract was entered into. It must go to the heart of the contract and be something that was not addressed already when the contract was signed. Again, we have this concept that it has to have arisen out of no fault of either party. And crucially, it must result in performance being either impossible or radically different from what was originally envisaged when the contract was entered into. There is no requirement, once again, that an event be unforeseeable. And what we can see from the recent case of Canary Wharf Limited against European Medicines Agency is that frustration is very much based on what is in the interest of justice and what is the right thing to do by the parties given the change of circumstances. And what the court said in that case was that whilst the interest of justice alone could not be determinative, you couldn't make a decision on a frustration case without at least having consideration of it. In applying frustration to COVID-19, and some of the difficulties we might have there, it may well be the case that it's no longer possible to perform a contract, and this could be because of increased global demand, government requisitions, or export controls that may have been imposed on goods and materials, or you may simply have an inability to mobilise your workforce at this time. The problem, though, with reliance on the common law doctrine of frustration is that the test is very likely to be much harder to meet than under any force majeure provision. With frustration, you need to be able to show impossibility or that performance is now going to be radically different. Whereas, again, depending on the wording of your contract, a force majeure clause may only require you to show that performance has been delayed or hindered, which is clearly a lower threshold. It also doesn't seem to apply to short-term hindrances. And at this stage, we don't know, obviously, to what extent and for how long COVID-19 may impact your business. The courts also appear very reluctant to apply it, and they're keen to ensure that it's not used as a mechanism to escape a bad bargain. It is likely to be more difficult to apply to contracts entered into after the outbreak took place, after the outbreak began. And I said that a lack of foreseeability is not necessary, but this will lead weight to the argument that the contract already caters for the specific issue because it was known to the parties when they signed up to it. And finally, and critically, under frustration, the contract is brought automatically to an end. It is automatically discharged. There's no scope to suspend performance until the event passes. And therefore, you're going to lose all business opportunity that came with this contract. Supervening illegality, this is where performance becomes illegal after the contract was entered into. It's often seen as part of the law of frustration, but it can be considered as a separate doctrine, and that's because there's more of a focus here on public policy, and the courts will not be willing to enforce an agreement which is illegal. And there's less of an attention paid to what is in the interest of the parties in that situation. It does apply when performance becomes illegal under either the governing law of the contract or the law of the place of performance, or indeed the law of the place where the contract is being litigated. And it may be a popular avenue for claims if it's going to be difficult to show that performance is impossible or radically different, but there is some legal prevention. In applying it to COVID-19, like frustration, the test for supervening illegality is that you'd have to show that performance isn't simply more difficult, but it's now illegal. This may be straightforward for contracts relating to perhaps the hiring of venues for things such as weddings, which clearly are now illegal under Scots law. But the coronavirus regulations are limited in their legal requirements to close, and the requirement to close is focused on leisure and retail outlets. And much of the other information is just guidance or encouragement on other businesses to close. And if you'd like any further information on the scope of these regulations, then again, please do let us know. But it's just to be aware that you need to exercise some caution there, that there might not actually be a legal requirement on your business to close at this time. As with frustration, again, the contract will also be discharged in its entirety. So there will be a loss of that underlying commercial value. In summary, as I've already said, the issue is going to be about balancing risk versus reward. Yes, entering into a written agreement is likely to increase costs, at least to a small amount in the short term. And yes, it might take more time to negotiate a contract, but this must be weighed against the risks of not having this written agreement. So we'd ask businesses to consider whether the contract is taking place over a long period of time, and if a verbal agreement could simply be forgotten. What are the risks right now of parties acting in bad faith, particularly in light of COVID-19, which is placing, for many businesses, unprecedented strain on them? Are you placing too much reliance on institutional knowledge, especially at a time when many persons are going to be absent from the workplace? Would a lack of force majeure provisions expose you to excessive risk, or do you think that an ability to claim force majeure is a useful tool that you might want to use, or at least have the opportunity to use going forward? Or is the common law an acceptable fallback when you look at frustration and supervening illegality? If the risks are too great, then the best course of action will always be to prepare a written agreement. In terms of formalities, we've already discussed the clear benefits of having this written agreement, but businesses might be struggling right now to actually practically get contracts signed. Not everybody working from home has access to a printer and a scanner. Whilst there's generally no requirement for signature of agreements, and that includes agreements that are committed to writing, the advantage of signing is that it is evidence of the intention to be legally bound, which is one of the key requirements of contract formation. If an agreement is signed, this is evidence that the contract is in final agreed form. So there is merit in signing wherever possible. Under Scots and English law, almost all documents can be signed, or the technical term might be authenticated electronically, as opposed to in the traditional wet ink version. However, certain documents can only be validly signed using specific type of electronic signatures. And the Law Society of Scotland has produced a very helpful set of draft guidance on this because of the COVID-19 outbreak, and this can be found on their website. Essentially, though, there are three types of electronic signatures. The first is a simple electronic signature, which could be something such as copying and pasting a JPEG image of a signature into a document. It may be the tick box exercise you get when you're signing up to terms and conditions for various media outlets, for example. Or it's the standard functionality that third-party service provider platforms have, such as DocuSign or Adobe Sign's basic functionality. The next level up is an advanced electronic signature. These offer greater levels of protection, but they're only available from third-party service providers. And finally, you have qualified electronic signatures. Now, these are the highest standard of e-signature, and they're the only way actually for an electronic document to be self-proving under Scots law. And that is that they're presumed to be validly executed, and it would be for the party claiming otherwise to prove that. As the service provider needs to validate the identity of the individual first, a qualified electronic signature has historically been less common, though we are now seeing new services where the individual's ID is verified by video link. In fact, all Scottish solicitors have a qualified electronic signature built into their Law Society smart cards, and these can be used where signing documents on behalf of clients, or if you're working in-house, on behalf of employers. What e-signatures allow for is the potential to sign documents without the need of this printer and scanner, or the need to post hard copies to a counterparty. Parties can sign documents provided they just have access to a laptop, the internet, and a copy of the signature on file, so it makes the process that much more convenient when working remotely. However, we should stress that there are still issues when using electronic signatures. Firstly, under Scots law, certain documents can only be signed electronically if an advanced electronic signature or higher is used. And these are set out once again in the Requirements of Writing Scotland Act 1995 at Section 1 and the Electronic Documents Scotland Regulations 2014. These cover things such as the signing of agreements for the transfer of land. If self-proving status is required or desirable, then a qualified electronic signature must be used. Many off-the-shelf e-signature platforms don't meet the standard of advanced electronic signature or qualified electronic signature, and so you'll need to check whether and how they can offer this additional functionality. Notwithstanding this, though, certain documents still have to be signed in their traditional wet ink format under Scots law, and these include things such as wills, but also documents that have to be registered with Registers of Scotland, and this includes documents that have to be registered in the Land Register. The use of simple electronic signatures also comes with the greatest degree of risk in terms of evidencing that intention to be legally bound. For example, simply inserting a JPEG into a document provides little assurance as to the identity of the signer. So we do advise businesses to carry out risk assessments of whatever proposed signing solution they're looking to use and the security features that come with that or they might need to put in place. And to very much do this on a case-by-case basis. Parties should also be aware that there may be foreign jurisdiction elements to their contracts, and the laws of that jurisdiction may or may not allow for electronic signatures. It's something, once again, to be aware of. And finally, on a more practical level, if parties use different electronic signing platforms, this can lead to compatibility issues. So we do advise clients that at the outset of a transaction, you agree which e-signing platform you're going to use. There's no doubt electronic signatures can be complex, and it's not always easy to match the technology offered with the classifications that we've discussed above in terms of simple, advanced, and qualified electronic signatures. And your approach is going to have to vary depending on the type of contract and the risks associated with that. It's important, we think, that organizations have in place a policy or a playbook on what sort of documents they're happy to have electronically signed and the type of signatures that are going to be used and who's going to be in control of this process. Bruce has advised a number of organizations on the development of these playbooks, and we'd be happy to help you navigate through this. This is, of course, a very brief overview on e-signatures, and I will point out that my colleague Martin Sloan has written an excellent blog on this, which can be found on the Brody's website. I will now pass over to Erin, who's going to discuss some solvency risks.
Okay, thank you, Adam. So, given the ongoing economic impacts of the pandemic, it's really more important than ever that we consider counterparty risk. So, while your own business might be in a really strong position, you should be considering the risk that insolvency of a key client or supplier could have on your firm. So what I'm going to do today is just have a wee run through of some practical tips that will help you to do that. So let's look at warning signs first of all, as knowing these warning signs is really your first layer of protection. So typically what we see are 3 phases to a company's decline. The first phase is underperformance. So what we start to see here is that the company begins to lose profitability due to some weakness in its business. So we might see a company losing its market share to its competitors following consistently poor performance, for example. Stage 2 is distress. So this is where the business is only able to fund its immediate operations, and we begin to see difficulties in that business meeting its commitments to creditors and lenders. And the third and final stage is crisis. So at this point, the cash shortage has become critical, and the company is forced to utilise all cash within the business just to meet its debts as they fall due. Now, as with any of these things, it's not a hard and fast rule, and of course, not all businesses are going to decline at the same rate. So a lot of you might remember Zavvi Retail Limited. It was a fairly well-known high street brand a number of years ago. Now, much of Zavvi's stock was sourced from a company, Entertainment UK Limited. That was a subsidiary of Woolworths PLC, so you can maybe see where this story is going. On the 27th of November 2008, just around that key Christmas trading period, Entertainment UK went into administration, and that meant that Zavvi was left short of stock. Now, the effect on Zavvi was extreme, and it was pretty much immediate. So due to their lack of stock, Zavvi was unable to generate sufficient profit over the Christmas period to allow it to fund its operations into early 2009, and entered into administration on Christmas Eve 2008. So that was just 1 month after Entertainment UK. Now, I think this is a really good cautionary tale. It's a good example of business decline setting in very rapidly, and it was following an external shock, which was completely out of the control of that business. So this is why we need to know the warning signs and how to look out for them. So a major warning sign, and probably the most obvious one that would spring to mind, is that payment of invoices is not forthcoming, or potentially payment is forthcoming eventually, but it's much slower than it has traditionally been. We might find that a company in distress will try to delay payment of invoices, maybe by disputing them, or it may try to divest itself of certain contracts completely by alleging contract breaches and then attempting to terminate the contract off the back of those. You might find that a struggling counterparty is failing to perform or failing to commit resources to a particular project, or there might be a sudden lack of responsiveness or engagement with you. On the flip side of that though, you might find there's a sudden surge in engagement in the form of variation claims on an industrial scale, and that's really just the company trying to manage its cash flow as much as it can. Selling assets and downsizing resources or personnel is of course consistent with a company that's under stress, and unfortunately that's something that we're seeing in a huge scale at the moment across the country and globally. Another thing to look out for is that a company that is beginning to struggle might start to communicate more formally than they have before. So you might see a company that had traditionally favoured telephone correspondence will start communicating by email. So what they're trying to do here is to create a paper trail. What you need to be doing is watching out for signs of professional or legal input in their communications. Another thing you might find is that as cash flow becomes more restricted within the business, senior management will become more involved in the day-to-day running of the company. So you're usual contacts might have their authority restricted. And a way to spot this is by looking for unfamiliar names copied into emails. So check distribution lists, email chains, look for the names of senior personnel, people that you don't recognise that are suddenly being copied into all your communications. And a final warning sign, you should consider whether your counterparty has any outstanding court judgments against them. So look out for judgments online, which I'll go into in a bit more detail shortly. Look out for late filing of accounts on Companies House. Another warning sign could be new Phoenix companies being incorporated by the directors of your existing counterparty. So when we say Phoenix companies, that is to say new companies effectively rising from the ashes of the old. And what happens is these companies can be created as a vehicle for a pre-pack purchase of the business and assets of an insolvent company. So that's something to look out for. Now, moving on to spotting the signs, we've identified what key warning signs are, but you need to know what you can do to spot them. Now, as with anything, really, knowledge is power. Now, as I mentioned earlier, keeping an eye on Companies House is always a worthwhile exercise. It's free to do. You've got nothing to lose by doing it. It's really straightforward. It can be done using the online facility. So just search Companies House using your preferred online search provider. And this will allow you to check the status of the company. So you can look for things like whether its accounts were filed on time, and maybe whether there have been any material changes within the company. In addition to this, and something that I think a lot of people don't realise, is that you can instruct a credit check on a business at any given time, just to search for red flags, basically. And this can be done via a number of credit referencing providers, and it is something that we do offer here at Brodie, so we are able to do that for you if you wish. And depending on the level of subscription that you choose, you can sign up to some really useful features. So where you've got a counterparty and you have serious concerns that they might be struggling financially, one thing you might want to do is set up an alert so that you are notified if and when an application is made to Companies House to strike off the business from the register. Another tip that I would usually give at this point is to check the court rolls. So they can be a really useful source of information in respect of who's being sued for payment, or what companies are having petitions for liquidation raised against them. Again, they're available online and free to access. Due to the pandemic though, courts are only dealing with urgent actions, and so it's really unlikely that the court rules are going to be as useful an information source as they would be usually. However, it is something to bear in mind once the courts do eventually go back to providing a full service. A couple of other things you can do, you can check the press. So quite often local media will cover events that could signify the financial distress of the company. So again, we're looking at things like refinancing of the business, or redundancies is another obvious one. And of course, one that I think doesn't get enough credit is the grapevine. You can obtain quite a startling amount of information on the grapevine. Now, I hope it goes without saying that I'm not suggesting you utilise this as your sole method of knowing your counterparty, but it may be that you can just pick up wee bits of information here and there that could prompt you to carry out further investigation. So quite often, staff at the front line of a company will pick up on an ease and decline in the business long before any official statement is made by the company itself. So just look out for signs of concern in the staff that you deal with, and listen to little bits of information that they might unwittingly give away. Have staff benefits been reduced or possibly cancelled? Have staff numbers been cut? Or maybe staff are just complaining that management aren't communicating with them as regularly as they would do usually. And finally, on this point, maintain good internal records. And I can't really stress the importance of that enough. Consistently tracking the payment profiles or delivery schedules of your counterparties might highlight where there are changes to those payment schedules or where deliveries become erratic. And this could just allow you to pick up on a counterparty in distress a little bit earlier than you might have otherwise done. Now, unfortunately, I wish there was, but there's no catch-all solution for identifying when your counterparty might be struggling. But what I would say is that using the tips I have very briefly run through here, you will be as prepared as you can be. Now, I'm going to briefly hand back to Adam, and he's going to talk through certain contractual mitigations that you might want to consider adopting to protect your business.
Thanks, Erin. I just wanted to quickly point out that there are a number of contractual measures that you could also adopt in respect of how payments are structured, and that might be particularly helpful during the current crisis. The standard approach, as I'm sure you'll all know, particularly with short-term contracts, is that payment follows performance, and this protects the party who's not responsible for actually carrying out the work, because it ensures that the other party is incentivized to perform, and also to perform properly before they receive payment. However, because of the economic impact of COVID-19, many businesses are not going to have had revenue streams for possibly the last 3 months. And this could mean that they don't have the necessary funds to perform a contract without any payment. So there are some things you might need to consider in terms of payment structures, and one of these is the potential for using advance payments, which is where the contractor gets paid upfront. You could also use interim payments where they're paid in equal installments, or finally milestone payments where the contractor is paid up to the value of work completed once certain key parts of a contract are performed. Now, each of these methods has its own benefits and has its own drawbacks, and once again the businesses are going to need to adopt a risk versus reward approach, and we can certainly give you more information and guidance on that. One of the good things is obviously that you can make these provisions as detailed or as simplistic as you like, so they can be catered to deal for your specific circumstances. I think it is likely that the longer the gap between commencement of performance and payment, the more likely it is that many contractors at the moment are going to be looking for alternative payment structures. I will point out as well that these issues were discussed in more detail once again in our January presentation, so please do let us know if you'd like some more information on it. Erin, I'll pass back to you there.
Okay, so we're on the home straight now. Dispute resolution. So you'll all be well aware of this, but even with the best will in the world, disputes are going to arise from time to time in business relationships. So what I'm going to look at now are ways in which you can seek to avoid disputes, ways in which you can negotiate a resolution, and I'm going to run through some of the most commonly used dispute resolution methods. So avoiding disputes, first of all. Now, of course, this is the plan A. This is what we want to do, is avoid disputes wherever possible. They're time consuming and expensive, and they consume limited resources within your business. Generally, a court is going to view lost management time as an irrecoverable expense, so you're just never going to get that time back. There's also a risk that the outcome of a dispute could negatively impact your business in some way, and perhaps most importantly, it could be really damaging for long-term business relationships. So the first line of defence against disputes is careful drafting of the contract, as Adam has discussed already. Now, by clear drafting, we mean clear and concise agreements written using unambiguous language. This seems really straightforward, but it's so important. And it can be the difference between a lengthy and costly litigation and there simply just being no dispute at all. The second line of defence is a more practical one, and that is to have proper contract management processes in place. So you should know what contracts you have in place, what they say, ensure that important dates and milestones are diarised, so things like break options, for example. You should ensure that contracts are stored securely, and wherever possible, you should look to have an electronic backup of those. Far too often, as Adam has alluded to, businesses do tend to rely on the knowledge of their long-serving staff. But what happens when that staff member is taken ill or they retire, or at the moment, the bigger risk is that they're furloughed. So much of that institutional knowledge is just going to be lost. And the third and final defence is contingency planning. So where events seem to be taking a turn for the worse, for example, in the midst of a global pandemic, having had the foresight to work out your plan B can prove invaluable. So addressing these what-if events now can save you so much time and money further down the line. So consider your exit strategy in relation to your contracts. Do you have flexibility to terminate, for example? Or consider what the effect of a breach of contract by your counterparty might actually be. Where you do find yourself in the midst of a dispute, so where these 3 lines of defence haven't had the desired effect, this doesn't mean that the situation has to become adversarial and that relations between the parties will be damaged beyond repair. It may be possible through mutual discussion to reach some kind of settlement that both parties are satisfied with. Now, I would imagine that most of you attending here today are going to have been involved in negotiation at some point in your life. So it can be anything from negotiating a better price for your car, or maybe just securing a better broadband package. So you probably have a lot more experience in this already than you would initially realise. And there are clear advantages to negotiation. It's voluntary and flexible, and usually it's going to be fairly quick and cost effective. However, it's worth noting that it can lead to delay or be used as a fishing exercise for discovering information if there is an absence of good faith by a party, and it doesn't always result in a deal. So you could find that you take part in a protracted negotiation and are still required to seek resolution by way of court or arbitration proceedings further down the line. In any negotiation, the golden rule and what you want to be doing at the very outset is to consider your best and worst alternatives to a negotiated agreement. And this will allow you to properly evaluate any offer that might be made by your counterparty. Another thing that you should consider is the realistic alternative to a negotiation agreement. So, alternative being one achieved through litigation or arbitration, for example. Think about how long it will take to get a result if matters aren't agreed today through negotiation. Consider what the cost of not doing the deal is going to be. Of course, it's imperative that you know your rights and obligations before you enter into any negotiation, and that's key to being successful. So what Brodies will quite often do for clients is we'll ghostwrite their communications, and this just ensures that the right buttons are being pressed in the right way and at the right time. A further key element in effective negotiation, and probably the most obvious one, is communication. Now, research has shown that the primary importance that we place upon an individual's approach to communication as part of any negotiation is not actually on the words spoken. Instead, words make up only 7% of the overall effectiveness of communication. Now, I find that quite staggering. Obviously, this doesn't mean that negotiators should not choose their words carefully. The words you use are still going to be really important. And the last thing you want to be doing as a negotiator is using language which throws fuel on the fire. Your voice, more than the words that you use, is going to have a significantly larger impact on the effectiveness of your communication than the actual words and language used. So, in any negotiation, ensure that you are being clear, take your time, pause where appropriate, and try to adopt a tone which is confident and firm, but still polite. Effective delivery of your message is key. Negotiation is not simply about making your point, but it's also about ensuring that your counterparty hears what you have to say and has taken that on board. A couple of final points on negotiation. When you're negotiating face-to-face, which I can't imagine any of us are going to be doing in person for quite some time, but behaviour is by far the most important aspect of communication. So consider your posture, the gestures that you make, and the level of eye contact. They're all key. I would hope that it goes without saying that listening is imperative to a productive negotiation, and you really need to be listening to your counterparty for two main reasons. The first being to understand their position, and the second being to assess the strength of their position and the potential impact it could have on your business. And that will just allow you to take a commercial view on the best way to proceed. And I should note too that while I said there that we're unlikely to be negotiating in person anytime soon, each of these principles is still going to apply when negotiating by way of video conferencing. And I expect that is something that we're going to be seeing more and more of in the coming months. So moving on to the various methods of dispute resolution. So envisage a situation where a dispute has arisen with your counterparty and you have tried to negotiate a resolution to the matter without success. This can be really disappointing, but it does happen. The first thing you want to be doing is checking the terms of your contract in order to identify the agreed method of dispute resolution, if indeed it is stated in the contract at all. Broadly speaking, the agreed method of dispute resolution is going to be either litigation, mediation, arbitration, or expert determination. Although, where the dispute involves construction contracts, parties will have a statutory right to adjudicate. Some contracts will contain tiered dispute resolution clauses, providing for several stages involving different methods of dispute resolution, just to complicate things for you. But if you do find yourself in that situation and you're unsure as to which dispute resolution method applies, please feel free to approach us and we can certainly advise on that. So we're going to turn now to the advantages and disadvantages of each of the dispute resolution methods that I have mentioned. So let's start with court action. I think this is probably where most people's minds will go when they think about the resolution of contract disputes. Now, as I mentioned earlier, court action is not as accessible to disputing parties at the moment because of the pandemic. So courts are generally only dealing with urgent matters. So they're prioritising crime, child welfare issues, and actions which are about to time bar, for example. So it's for this reason I'm not going to focus on litigation in any depth today, but the pros and cons are set out in the slides for you to read at your leisure. What I am going to focus on are alternative dispute methods which are routinely carried out remotely and which remain readily available to you at this time. So if we look at mediation first of all, now this is a voluntary, confidential form of dispute resolution where generally parties will attend a neutral venue and a third-party mediator will facilitate communications between them with a view to reaching a settlement by the end of the day. Key advantages of mediation, and I mean the first one is a particularly key advantage at the time. Mediation is capable of being carried out remotely. So it's available in a similar format to traditional mediation through a number of providers. Now, remote mediation is something that the dispute resolution team at Brodie's has experience in. So if you do find that you have a dispute that you think might lend itself to mediation, or if you're keen to resolve a particular dispute sooner rather than later, particularly bearing in mind the backlog that the courts are likely to see when things do open up again, please just get in touch and we can certainly talk that through. Next advantage, mediation might allow parties to avoid incurring time and cost of bringing or defending court or arbitration proceedings, and it can often resolve disputes quickly before they have a chance to escalate. Parties to a mediation will negotiate their own settlement, so that means that they can maintain control over the outcome of the dispute, and that's not something you would have, for example, in litigation, where the decision is completely taken out of your hands. A further advantage is that as a neutral third party, the mediator can offer a little bit of a reality check to parties' assessments of the relative strengths of their case. And mediation is particularly useful in preserving good working relationships between disputing parties. Turning to the disadvantages now, mediation is not always going to result in a settlement agreement, so parties might spend time and money on mediation only to find that the case still requires to go to court or arbitration, for example. Mediation can be used as a fishing exercise for the discovery of information where a party is acting in the absence of good faith. And it's worth noting there as well that mediation doesn't have a formal discovery process, so parties can't be compelled to exchange information in the same way that they would be, for example, in a court setting. And a final key disadvantage is that mediation is only as strong as the willingness of the parties to negotiate in good faith. Now, what I mean by that is that you cannot compel parties to mediate, so the success of the process is wholly dependent upon the parties' appetite for resolution. Now, in saying that, the percentage of mediations which result in a settlement agreement is very, very high, but it is just something still to bear in mind. So moving on to arbitration, which is essentially a private dispute resolution. It's a determination by an independent third party. A similar advantage actually of arbitration is that even in normal circumstances, a great deal of the work involved in an arbitration is undertaken online rather than requiring the physical presence of the disputing party or their representatives. So arbitration therefore lends itself easily to circumstances such as this, where not only are parties probably unable to travel internationally, but they might not even be able to leave their own homes. Again, parties can choose their decision maker, and this means that they can select one with an appropriate level of practical experience for the matters in dispute. Parties can select bespoke rules to apply to the arbitration if they wish to do so, and it is possible for parties to place a time limit on the length of the process too, so that can mean that arbitration may be faster than court proceedings. Arbitration can be cheaper and more flexible than court, and the proceedings themselves and the subsequent awards are confidential. There are limited avenues for appealing an arbitration award, so that can mean that the lifespan of disputes is generally shorter than in litigation, where you might have a very lengthy court action only to find that when you finally get your determination, it's appealed and you then have another lengthy process to go through. And a final advantage is that arbitration awards are easier to enforce internationally than court judgments, so depending on the reach of your business, that might be a real draw for you. Disadvantages: parties must pay for the arbitrator and all facilities, so that adds an additional layer of costs that you wouldn't incur in a court action. So for those of you that are speedy readers, the pros and cons list for litigation refers to the fact that the sheriff or judge, the courtroom, they're all provided for you as part of the process. In a court action, you do have to pay some court dues for lodging certain documents, for example, but they're fairly negligible. They are heavily subsidised. Now, flipping one of the advantages of arbitration on its head, the limited avenues for appeal can also be a disadvantage, because it means that an erroneous decision by an arbitrator cannot be easily overturned. Further, although arbitration is thought to be faster and cheaper than the court process, it can actually sometimes take just as long and be more expensive. And a final disadvantage is that it is not possible to obtain a default judgment in arbitration in the way that you can in litigation. So in litigation, if you sue for a specific amount and the action is not defended by the other side, a court can award a default judgment in your favour for the sum sued for. By contrast, in arbitration, you might still find that you're required to jump through certain hoops in an undefended action before an award is actually made. So moving on to our fourth dispute resolution method, expert determination. So this is a formal dispute resolution process whereby parties appoint an expert to determine the dispute. The key advantages of this are that expert determination allows for the appointment of an individual familiar with the relevant specialism and technical issues. Usually it's going to be cheaper and quicker than arbitration or litigation, and it can be useful for maintaining business relationships, just because it is slightly less adversarial than litigation or arbitration. And a further advantage is that it can dispense with the need for parties to instruct their own independent expert witnesses. So that just strips away an additional layer of cost there. However, the key disadvantage of expert determination is that the law in this area is just not as well developed yet as the law in respect of other dispute resolution methods. So if you have an expert determination clause in a contract which is not particularly well drafted, this can lead to uncertainty and subsequently additional costs and delays. Again, in a similar vein, the expert's remit will be dependent on the contractual provisions. So in arbitration or litigation, we have various backup rules and procedures that we can rely on, but that's not the case with expert determination. You would simply be dependent on the clause as it was drafted. Expert determinations cannot be enforced without court action to implement them, so you might want to consider that if considering an expert determination, that in order to enforce the decision made, if it's made in your favour, you will have to take court action to allow you to be able to do that. And finally, beyond fraud or bad faith, there are very limited rights of appeal or challenge to an expert determination. Now on to the final dispute resolution method, so adjudication. This is a slightly different one in that an interim binding decision is imposed by a third party, and it is a compulsory dispute resolution method in the construction industry in the UK. So a major advantage of adjudication is that it's speedy. So generally you're looking at a 28-day process, although there are certain circumstances in which this can be extended. And in part because of this, the speedy process element, it's cost effective. Just by nature of the shorter procedure time, preparation costs are curtailed quite significantly. Each party will generally bear its own costs in an adjudication as well. Adjudication proceedings are private unless the adjudicator's decision is later subject to enforcement proceedings, and it's very flexible. Again, parties can choose their own decision maker. Disadvantages, again, flipping the timescale element on its head, the timescales involved might result in parties having insufficient time to carry out full investigations to present their case in the same way that they would in a court action, for example. And a perceived disadvantage of adjudication can be the rough justice element, whereby tight timescales might mean that an adjudicator is rushed into making a decision on a particularly complex legal or factual matter. And as I said there, generally each party is going to meet their costs, so you won't usually be able to recover your costs from the other side if you're the successful party. So we can contrast this with litigation, where the general rule there is that expenses follow success. It's not a hard and fast rule, but it's a general rule, whereas in adjudication, regardless of whether you win or lose, you're unlikely to be able to recover your costs. So just to sum up on this dispute resolution section, you should consider your dispute resolution clauses really carefully when you're drafting your contract. Consider whether you really want to have a provision whereby every dispute has to be litigated. Think about whether you want to have an escalation provision whereby a dispute must go through certain internal processes before an external method of dispute resolution is going to kick in. And consider your priorities in the event of a dispute. For example, is salvaging the business relationship of particular importance to you? And bear in mind as well that the answers to these questions may well differ from contract to contract. So you should take the time to review your dispute resolution clause and don't just view it as a kind of cut and paste boilerplate provision. And one final thing I would say today is that Brodie's can assist you at every step of the way. So whether that be in drafting bespoke dispute resolution clauses, negotiating on your behalf where a dispute has arisen, or potentially representing you in the resolution of a dispute using one of the methods I've discussed, we do have a wealth of experience in this area, and we would be more than happy to assist you in any way that we can. Now, I'm not sure if we do have time to answer questions, but I am going to pass you back to Ken for that. Thank you.
Okay, thanks for that, Erin. There's been quite a few questions, and those that we don't ask, we will certainly respond to by email and contact you. In the interest of time, and we do like to stick to the advertised time, I'm just going to ask the one question. We've had a lot of questions on force majeure. I'll put this question to our panelist, Brian. Is a pandemic covered by act of God wording in a list of force majeure events in a contract, Brian?
Thanks, Ken. I suppose this will ultimately depend on the wording of the contract. However, there is opinion that an act of God, referring to natural disasters, may extend to pandemics that are essentially natural disasters caused by viruses rather than geological or weather-related events. This view would be strengthened if acts of God expressly include pandemics within the wording. Case law has indeed held that sickness can constitute force majeure. However, there is a counter-argument that the pandemic itself may not be preventing performance, but rather the response of governments to it. As far as we know, this has not been tested in court yet, and it may be easier to claim force majeure based on governmental regulatory interference as opposed to acts of God, if the wording allows for it in the contract.
Okay, thanks for that, Brian. Sorry that we haven't managed to answer the questions that have come in. There's been quite a lot of them, but we will get in touch with you with our responses. And thank you very much for attending this Brody's webinar. Stay safe, and we hope to welcome you back for another webinar in the future. Thank you.